Welcome to today's special webinar, Current State of Tariffs and Trade, a Small Business Perspective, brought to you by NFIB. To our current NFIB members, thank you so much for being an active participant in the small business conversation and for your continued support. To those who are not yet members, welcome, and consider joining the nearly 300,000 small business owners who are fighting for small business with NFIB. Our success is based on strength in numbers. Each new NFIB member makes our voice a little louder and strengthens our efforts to fight anti-small business legislation. If you are or know a small business owner who needs their voice to be heard, visit NFIB.com or call 1-800-NFIB now. And before we begin, here are a few housekeeping and announcements. If you have any issues with audio, ensure your computer speakers are set up properly and know that your internet connection does affect the clarity of sound. We are recording today's presentation, and after the webinar, all registrants will receive an email with a link to the recorded webinar and link to download the slides. We encourage you to, we typically get hundreds of questions during these webinars, and most of you have submitted your questions prior to the webinar, so we'll be getting to as many of those as possible today. So before we begin, I would like to introduce our speaker, Mitch Zajac. He's a shareholder practicing in Bustle's Detroit office. Bustle's? Oh, Mitch, please correct me if I got that wrong. He earned his Juris Doctor from Western Michigan University, Cooley Law School, and his Master of Science in Mechanical Engineering from WMU, his Bachelor of Science in Mechanical Engineering from WMU, and Bachelor of Arts in German from WMU, League Honors College. Mr. Zajac has been recognized by several influential legal publications for his experience in the areas of commercial litigation, intellectual property law, and patent litigation. And we have Holly Wade, Executive Director for the Small Business Research Center. Holly, I'll turn it over to you. Thank you for speaking with us today.
Great. Thank you, Casey. Hello, everyone joining the live webinar, and also to you who are watching the recording. Just a note before we get started, if you have any questions after this webinar or questions submitted that we weren't able to get to, please email those questions to info, I-N-F-O, at nfib.org. We monitor the email box many times a day, and you should expect to receive a prompt response. I will now turn it over to Mitchell to walk us through the recent trade policy announcements and what they mean for small businesses. After his presentation, we will answer pre-submitted questions. And again, if you have questions after or during this presentation, you are welcome to submit those at info@nfib.org. We have a lot to cover, a lot to talk about. Thank you, Mitchell, so much for joining us. And okay, here we go, and over to you.
All right, thanks so much, Holly, and thanks everyone who's in attendance. And as Holly said, those watching the recorded webinar, certainly a pleasure to be here and talk about a whole list of things. I typically, we have a narrow presentation scope, but in situations like this, the "and more" at the end of the title certainly is appropriate. Just a really quick introduction. Butzel is a firm that is rooted in Michigan and rooted in the supply chain industry. Back in 1854, we were formed as part of the maritime law push in the Great Lakes, and since have expanded to a full-service law firm based in Michigan, but with a presence in New York and DC, as well as with a global presence as a result of our affiliation with Lex Mundi, which is a global affiliation of law firms that allows for really point of contact in every jurisdiction, state, and country around the world. We are the automotive and manufacturer suppliers law firm. So the issues that you as small business owners are dealing with, whether it's manufacturing and automotive, but also just industry in general, we are here to support you. We work across the country in a variety of industries, not just the automotive industry, but also in the pharmaceutical industry, and the agriculture industry, and the various franchise industries, whether it's coffee shops or the like. We do all of that kind of work. And we get the opportunity often to talk to small business owners like you and business owners in general through our participation with a variety of industry groups around the country and around the world. I appreciate the great intro from me, so I don't have to spend too much time on this slide, but I do want to introduce the rest of my team that's not presenting here today. Our international trade team includes myself, Kate Carroll, Les Glick out of our DC office, and Andrew Abdul Noir out of our Ann Arbor office. And with this group, really, we're focusing on all issues when it comes to international trade. It's the tariffs, it's responses to customs inquiries, it's supporting valuation questions, anti-dumping, and the like, things that we get involved with as an international trade team. So the plan for today, there's going to be a lot of slides that I don't get fully in the weeds on, but as been mentioned, you'll receive a copy of this presentation afterwards, and there'll be, I'm sure, more information there than you'll glean from my discussion today. And also, you have my information. You can certainly reach out. Would be happy to engage with any of you in order to help support you in the business. So we're going to talk about where we are. We'll talk about the most recent Liberation Day, as well as the reciprocal tariffs that have the country-specific application that went into effect today on April 9th. Then we'll also talk a little bit about some specifics of what it means to be U.S. content, USMCA content, who's on the hook for tariffs, and kind of a tariff 101. And lastly, other options for tariff mitigation. So to start out, the issue with tariffs really began with the president's America First trade policy from January of this year. And it set out a variety of different initiatives, some dealing with the Treasury and Commerce, some dealing with the USTR and focusing on China, some dealing with Homeland Security, and then a variety of other industries that were really poised with the premise to help American workers, farmers, ranchers, and service providers that have been doing business with in the United States, and that the president believes is subject of unfair trade practice and really being out marketed and outworked in the industry anyway, or out positioned in the industry by foreign trade partners. The key tools, and not to get too deep in the weeds, but these are important. Really, the first two and the last one are the ones that we're seeing mainstream today. Section 232 tariffs that deal with questions of threats to national security. Section 301 tariffs, which deal with unfair trade practices. It's the underlying tariffs that have been in effect with China since the first Trump administration. There's Section 201 tariffs, again, dealing with issues with domestic industry that has been identified by the ITC, the International Trade Commission. And then, as we're very familiar with, the IEEPA, the International Emergency Economic Protection Act, looking at questions of imminent or immediate national security threats, which is the basis for the majority of these new significant tariffs. Those that have taken effect most recently, many are familiar with the steel and aluminum tariffs. There's been, and I know there's been questions about what are the exceptions, as there used to be exceptions and exemptions rather for the steel and aluminum tariffs. Unfortunately, those are all gone. There are no more steel and aluminum tariff specific exemptions. The tariffs on steel and aluminum have also been expanded to cover steel and aluminum derivatives. Those derivatives are not necessarily what you would automatically think is a derivative steel product, but rather it's based on a list that's been identified by the Secretary of Commerce and adopted by the President in order to identify those specific products brought in under specific what's called HTS-US or Harmonized Tariff System identifiers. Unfortunately for this list, it has the opportunity to be expanded, and most recently, for those who partake, the derivative tariffs have been applied to beer cans and aluminum cans that are imported into the United States. So the cost of your favorite beverage likely has just gone up over the last week or so. And then lastly, questions about what it means to be qualifying for USMCA, specifically as it relates to automotives and automotive parts. Those are all governed by Section 232. The IEPA governs other tariffs that have been put into effect. This and first really tranche of new tariffs with Mexico and Canada are governed by the IEPA, with exceptions for those that are USMCA qualifying. And then the most recent, as mentioned, reciprocal tariffs are also governed. I won't be going through this slide in great detail, but when you get this presentation, you'll be able to see, as of today, what is in effect and what is coming soon from an overall tariff perspective. In the far right column of each table, you'll see really the authorities we just talked through, as well as in the second to right column, you'll see the various rates of duty that will be applied to the value of the goods that are imported into the United States. And really quick, what are the reactions? I know you're all here because you're having your own unique reaction, but some examples in the auto industry are price freezes and discounts being offered by the automakers. I think it's almost all of the North American OEMs have agreed to do their employee pricing, as an example. Changes in supply chain and Nissan deciding, for example, not to sell products that are being imported into the U.S. any longer in the U.S. There have been publications by the Associated Press and the Wall Street Journal talking about what the overall impact is, not only to the auto supply chain, but also to industry as a whole. And some of those examples you can see how Apple starting to source more product from India, imposition of tariff-related surcharges by Micron, and Howmet stopping shipments under what's called a force majeure event theory, which we'll talk about a bit later. And then also the solar people, in terms of benefiting from this, the solar industry has hoarded many of its products just because of early imports or perhaps slowed down sales. And that's going to turn out to be a benefit, as an example, for them because the product is here and they're not subject to tariffs. So quickly, let's talk through Liberation Day and what that meant. Many quotes in these presentations from the president that I think do a good job to paint the picture for the rationale, and certainly leave our opinions of the quotes aside. There's many people on both sides that feel a different way, but we just need to look at the facts as we go through this presentation. So the basis of the reciprocal tariffs, as you've likely heard, is a large and persistent trade deficit. Starting on April 5th, there was a duty on all imports except for those that are exempted, which you'll see some of those examples a bit later, effective April 5th. And then effective today is the country-specific implementation, and that turns out, based on yesterday's publication, to be 83 total countries. Under the IEPA, the total recent increase in tariffs, as an example, you see bolded is China with the asterisks, 84%. So we have last night implementation of a 50% response to China's increase on tariffs. We add to that the 34% that was originally announced on April 2nd. And then we do have to add, and you'll see a bit later, the initial 20% on China, and then also the 25% on China. So today, as we stand, very likely all products coming from China, with limited exception, are at about 129% duty. That's 104% under the IEPA and an additional 25 under Section 301. All of this became fully in effect today. As mentioned, the rationale under the IEPA is a national emergency, and essentially, the president has declared that if you want no tariffs, build your products and source your components and goods that go into your production from America. This basis, as he's been outlined, is that there's trillions of dollars of revenue being left on the table, and these tariffs will remain in effect until the president determines there's no longer a threat to the trade deficit and the underlying non-reciprocal treatment is satisfied, resolved, or mitigated. Oops. So how are these all calculated? There's a slide towards the end that really gives a couple of good examples of what we've identified as the tariff stacking. But in terms of how these reciprocal tariffs were generated, there was some math done by the administration that looked at the trade deficit compared to the amount of revenue associated with it, and came up with math to come up with these new percentages. And the baseline of 10% was applied across the board. So that also included any of the countries that may actually have a trade surplus, the U.S. may have a trade surplus with, still receive this 10%. And finally, additional reports are due to the president from the USTR and the Secretary of Commerce to address 301 and 232 and IEEPA tariffs. However, the most recent report from the USTR is said to support the basis that the president has relied on, and looking at things like intellectual property unfairness, the additional taxes that are applied to U.S. products that are exported, and other restrictive laws. And so this has all gone into the basis for the calculation. So there are a few exclusions, but again, this is not the normal we're thinking of. In the past, when there was a 232 steel and aluminum tariff, there was a process for filing an application to be reviewed. Similar for Section 301, there was a process for those applications to be reviewed. Now it's just an across-the-board exclusion for the reciprocal tariffs for any Section 232 tariff. So steel and aluminum tariffs, auto and auto parts tariffs, these all allow for exemptions. And there's a few other examples that we can talk about specifically, including even product that's already on its way. There's what I've identified as the in-transport exception. And the in-transport exception, as you'll see, any product that has been shipped prior to April 5th or April 9th, depending on which tariff we're seeking to avoid, is exempt from these reciprocal tariffs, as long as they're imported by May 27th of this year.
Mitchell, just for clarification on the exclusions, when you say that there's an exclusion for steel and aluminum, it's because they were specifically tariffed already, correct? And so there aren't additional tariffs based on which country they're coming from?
That's correct. It's a great question, Holly. Exactly, because it's really based on the executive order. The executive order for reciprocal tariffs specifically identified that any product that is already subject to a Section 232 tariff, whether that's steel and aluminum, whether that's automobiles or auto parts, or the derivative parts, the aluminum and steel derivative parts, they are expressly exempt from these reciprocal tariffs, which essentially means you don't have to pay 25% on the steel plus, say, 84% because it comes from China. You would only pay, from the perspective of the reciprocal tariffs, you would only pay the 25% on the steel or the derivative product.
Great, thank you.
Absolutely. There are additional exclusions. As I mentioned, Canada and Mexico have an exclusion as long as the product meets USMCA requirements, which I'll talk a bit about what that means here later in the presentation, as well as there is exceptions for the amount of US content that is included in any product. And what that means is if a product is manufactured in Europe, but it includes 50% US content, that means that only 50% of the final product that's manufactured in Europe would be subject to the European 20% reciprocal tariff. So you essentially get to deduct the value of US content from the final value of the product. But again, as long as it's only, there's at least 20% of the value is originating in the US. And then ultimately, there are, and I won't go through these quotes, but there are kind of caveats left in the executive orders, which allow for the president to modify, increase, or expand, which is something exactly we've seen overnight with the increase by 50% on China tariffs. So here's the full list of the exceptions for the reciprocal tariffs. As I mentioned, Canada products, Mexico products. Exception 3 is the in-transport exception. Again, anything that's already on its way to the U.S. will be subject to an exception for the reciprocal tariffs as long as it's entered by May 27th. There are, it's not a positive exception with exception 4, but basically you're subject to the high Russia, North Korea, Cuba, and Belarus taxes or tariffs if products come from there. There are exceptions for donations. There are exceptions for informational materials. There are exceptions for a specific list of products that are included in Annex 2. And here's, a couple examples of those would include well, really a whole variety. I think it's about 20 pages long. So we could certainly help you track that down and point you to that list to see if any of your products are automatically exempted by being on that list. And then as we've been talking about the 232 exceptions, that's exception number 8, anything subject to section 232. The 20% value exception as referenced in the previous slide. And then there are existing programs that are being adopted and able to be still applied. There's the Chapter 98 program of the HTS-US, which there's essentially predefined customs regulations that give exceptions. Some of the examples include if products are built in, let's say, Mexico, but they're using all content that was shipped from the US, and then it comes back into the US after some processing in Mexico, and then further gets processed in the US. There are exceptions that allow for a very significant reduction of the value of the basis for the tariff, such as just the amount of alteration performed in Mexico, as opposed to the entire value of the product. Unlike the other tariffs, the Section 232, the earlier IEEPA tariffs, this executive order allows for drawbacks to be applied, which essentially means if materials come to the U.S., they get processed and then shipped to another country. The drawback process allows for up to 99% of the tariffs paid to be repaid, reimbursed by customs. And then there are de minimis exceptions, and I'll talk a bit about that later, but essentially with a de minimis exception, if you bring in $800 or less per day into the US, then you don't even need to declare that value. You are able to not pay a tariff on that amount for $800 per day. Retaliatory tariffs, the questions about many of these countries exist, but as of today, my understanding is there's some Canadian auto parts retaliatory tariffs. The European Union has discussed retaliatory tariffs, but also on kind of a cooperative note, talked about reducing tariffs and reaching some sort of resolution that has not yet been finalized. As I've been talking about, China has implemented its own retaliatory tariffs, which has then triggered a follow-up 50% increase by this administration. As I mentioned, and we've talked about most of these, but I just want to call these ones out. There are a specific list of 232 tariffs, 232 tariff applicable parts and automobiles that have been published in the Federal Register. There is this expansion of the de minimis rule we just talked about, the increase for the China from the 34% now up to 104%, plus the 25% from Section 301 to a total of 129%. And then, as mentioned, the Canadian tariffs that take effect today. So quickly, what is USMCA content? This is a question we get often. Essentially, USMCA content is any product that can have satisfy really 4 criteria. It has a rule of origin designation that it comes from a North American country, so Canada, Mexico, or the US. It also has regional value content. As an example, for majority of the products of at least 75%, meaning at least 75% of the value based on certain accounting methods come from a North American country. Also needs to satisfy what's called the labor value content, which is a very complex set of rules. And finally, to the extent it includes steel and aluminum, the steel and aluminum requirement. This is important not only because of satisfying the USMCA exceptions that I've talked about, but also for understanding how additional exceptions can be applied to different products that are being imported based on the recent executive orders. So for automobile and automobile parts, the basis for the tariff is, as we've discussed, any of these products coming in from a foreign country into the U.S. Are going to be subject to the 25% tariff. But for those that have a preferential treatment underneath USMCA, meaning it satisfies those 4 elements that I just discussed, there is an option to reduce the tariff value by the amount of U.S. content that is imported into the U.S. And what that means is, let's say that a $50,000 vehicle is being imported into the U.S., but $20,000 is coming directly from the U.S. The dutiable value for that automobile would then be $30,000 instead of the full 50, because it has $20,000 of value that is attributable, wholly obtained, produced entirely, or substantially transformed in the U.S. For auto parts, there's going to be a process, but we have not yet seen what that process is. We do expect, even though we've not seen it published, that the same kind of process for U.S. content will remain, but that is yet to be seen. And that would just mean for the amount that is wholly obtained or substantially transformed in the U.S., again, we expect there to be a reduction in value, dutiable value for that specific product upon import into the U.S. All right, so the question halfway through with all that background is really who's on the hook. In this case, again, we're typically dealing with suppliers who are selling to OEMs, but this could be anyone in the supply chain except for, well, I guess really anyone. Everyone is a seller and a buyer. If you're the end customer, you're selling to your consumers. If you're a middle tier supplier, you're buying from your supplier and selling to your customer. So we just need to always have that kind of perspective that this is a kind of a two-way transaction, and that your role as a supplier and as a buyer both need to be considered, to consider whether you're on the hook as it relates to your supplier, and similarly whether you're on the hook as it relates to your customer. So,
and just for clarification, OEM stands for?
OEM stands for original equipment manufacturer, but it could really just stand for final customer.
Got it. Okay, thank you.
In this presentation, we're kind of thinking of General Motors, Ford, Stellantis. They're the OEM. But if this is, a coffee industry, the OEM would be, Big B Coffee or Small Business Coffee 123, and then your supplier certainly could be the person that is growing the coffee bean. It could be even a middleman, somebody who procures that coffee from Brazil and is simply acting as an intermediary to sell to you as the final customer. There's a lot of different importance based on those kind of supply chains that we can try to dive into towards the end of the presentation. But yeah, think of OEM as final customer, and this should all make sense no matter the industry.
Wonderful, thank you.
So that, no problem. So that being said, the responsibility is a question of contract. That gets confusing sometimes because the importer of record still has to write the first check, so to speak. And so kind of a Tariff 101, importer of record is the party responsible for bringing the product into the country. And before the product is fully released, the product has to be, certain paperwork needs to be filed, and customs duties need to be paid. That overall process for payment allows for, I think it's about 7 to 10 days for payment. And then after that, certain penalties and fees start to accumulate. So importer of record, the person who brings the product into the country, has the obligation in the first instance to write the first check. And that doesn't necessarily mean that party, though, is the one responsible at the end of the day for bearing the final obligation. Meaning, even though you're the importer of record, it may be your customer's obligation to pay you back, or it may be your supplier's obligation to cover, in which case you could set off the amount you owe them by that amount. These questions are all governed specifically by your contract, and there's really no set methodology because each contract varies based on the agreement between the parties. The Incoterms are an important concept to be considerate of because Incoterms talk about not only risk of loss, transfer of title, where the product is no longer the supplier's responsibility to keep safe, but it's now the buyer's, and similarly where the transfer of ownership takes place. but it also deals with who has responsibility for tariffs. In the Incoterms, there can be modifications. So as you'll see, it's not just the words of the Incoterms, but also other words of the contract that help complicate, I'll say, the issue. It's important to understand Incoterms are not law. There are aspects of a contract that the parties negotiate, and the Incoterms exist so as to try to I guess in general, simplify the communication about logistics responsibilities. Here's an example, or a screenshot rather, of the Incoterms 2020 and what they say, generally speaking, about tariffs. On the left is the three-letter acronym you might be used to seeing, very common Ex-Works, which is EXW, FCA, free carrier, FCA, and then also DDP, delivery duty paid, or DPU, delivery or delivered at place and unloaded. Very common, no matter the type of shipment that occurs, those are common terms. And on the right, you see obligations for duty as a starting point for these various Incoterms. So essentially, from an import perspective, the only time by definition the supplier or the seller is supposed to be responsible for import duties is under DDP situations. I say that generally speaking because by contract, many of these could be modified, and it's again a fact by fact analysis required to be sure we have a clear understanding of who bears that responsibility. And as I mentioned, you can't just stop at the Incoterm because terms and conditions between buyers and sellers can have language that says, as an example, Incoterm FCA applies, except that, pick your modification. So despite using FCA terms, that FCA term is modified to change responsibility, perhaps for tariffs, perhaps for risk of loss, perhaps for cost of logistics in general. Again, a very fact-specific assessment required. For those of you that are in the auto industry, here's an example of what each of the major OEMs terms say. I won't spend too much time here, but you'll be able to go back once you get a copy to dive into that. And some of those terms have modifications, as you'll see on this slide. Again, for those involved in the industry, definitely dive into this and feel free to follow up with any questions. So you've probably heard of force majeure. Question: what is force majeure? It essentially is a body of law that allows for excused non-performance, and that's in situations where certain, you've seen acts of God or tsunamis, or after the pandemic, we've counseled everyone to put in pandemic and epidemic. These things that are foreseeable, generally speaking, between the parties that would trigger an excuse not to perform. In the most recent court cases, there's risk here. The most recent court cases say that cost increases, generally speaking, do not allow for a force majeure claim. As I mentioned, the basis for force majeure is that if there is basically an unforeseeable event outside the contemplation of the parties, where it's really impossible to have predict or impracticable to have predict, then a party, or both parties rather, are excused from performance for a limited period of time. Generally speaking, these events are again defined by the contract, but in the absence of a contract or of a contractual term, what's called the UCC, the Uniform Commercial Code, which governs, generally speaking, the sale of goods between two parties, has what's called a placeholder, and it says essentially the same thing as these force majeure terms. If your performance becomes impracticable, doesn't have to be impossible, but if it becomes impracticable, then you are excused from performance and you have an obligation to allocate supply and try to act reasonably to help assist your supply chain. There are some cases that, as I mentioned, require that kind of this concept of impracticability means it's approaching impossible. But however, economics typically are not going to be excused. In Michigan, that's especially difficult. There are some very unforgiving bodies of law or cases rather that talk about this issue, and you can dive into this description of the Hemlock case for a better example. So before claiming force majeure, it's always, speak with a lawyer because it is a question of law, generally speaking. But there are risks. There could be the risk of your customer saying, okay, we understand, but now we're going to dive deep into your financials. Please show us all the information. Certainly, there can be economic or commercial hardships with the relationship. And then this other reference to a demand for assurance, your customer can say, we're reasonably insecure that you're going to supply us the parts you said you were or the products you said you were. Provide us an assurance. And in instances where this is for the sale of goods, that failure to provide assurance could in itself be considered a breach of contract. So you open yourselves up to risk without properly assessing the force majeure kind of position. And then similarly, there are requirements to ensure you're complying specifically with force majeure expectations. Under the UCC, it requires reasonable notice or seasonable notice. And under specific contracts, like as an example, the General Motors contract, an express 10-day notice is required. So you say, I've no longer going to be able to supply. I just learned this last week. Here's all the reasons. That's the type of notice that would be required. But if it's not force majeure, as we mentioned, there are risks. There are other opportunities. We can look at just the general enforceability of the contract, whether that's under Michigan law, those are familiar. The need to have an enforceable quantity term is very well established. There are some questions of some nuance, but essentially you have to have a quantity for there to be a contract. The concept of an estimate doesn't work. The concept of not having a quantity that says we'll just issue you releases or we'll issue you EDIs in the future, that's not enough to create a contract. And then also contracts of indefinite duration. So forever, we agree to sell to you as long as we want this product or as long as you want this product. There are options for exiting the contract in a reasonable time. There's a lot of detail here about that quantity turn exception, but I think I've given you, for the sake of time, a high enough level for the presentation. You'll be able to dive through these slides and ask, like I said, follow-up questions to the info email, or certainly feel free to reach out to me. Here's a couple of cases that deal with this. If you are interested in the law, the Michigan Airboss case is significant from the perspective of defining what is called a requirements contract. And the Higuchi and the McLean-Fogg case are significant because they are federal court interpretations of slight modifications of that requirements language. So for the legal buffs or the legal nerds like me, there's significant implications on not only the modifications from those court cases, but also the fact that they're federal court cases instead of state court cases. It does mean something, and the ability to rely on them for making a significant action. As mentioned, also indefinite durations, this concept of life of the program, as long as we need, these are not necessarily contracts of indefinite duration, as long as it's clear from all of the surrounding documents that the parties knew what that meant. So if it's, we're going to supply you this widget for this product for as long as you make that product, that generally speaking is not indefinite. However, you said, I'm going to sell you this widget for as long as you need it, but we don't know what it's for, or it could be used for multiple things. That could be deemed indefinite and give you an option to exit the contract. These are tools, in the face of tariffs on what you might do in order to exit contracts with reasonable bases that otherwise are rooted in other bodies of law. As discussed, always proceed with caution. And again, this is just a reminder slide that you can take a look at of essentially check with your lawyer before you do something that might cause a legal issue. All right, diving into tariff mitigation. I think we've got 20 minutes left or so. We should have great time for questions at the end. So the goals of tariff mitigation, as mentioned, a couple of times, some tariff 101. Essentially, these new tariffs provide for limited exception, as you saw, those 12 exceptions from all tariffs. They really are exceptions from the full brunt of tariffs and really offer opportunities for reduction of tariffs and duty obligations. As I mentioned, the party importing the products are the ones that are responsible for paying these through transactions with customs, doing so at the time of import, doing so by directly paying customs. So the goal of mitigation is to find ways to offset the impact. And we'll focus on this presentation on, I'll say with air quotes, really, what could be long-term tariffs. But again, none of this is set in stone. And as we've seen, subject to change. There are country-specific things we should focus on. There are steel and aluminum and other product-specific things we should focus on, like autos and auto parts. But we do think that those will be around for some time, just given the time it will take to fix the alleged issues. But less likely, perhaps, are the Mexico and Canada tariffs and users of tariffs on consumable goods like oil, etc., from Venezuela and Russia. Ultimately, that those things won't go away per se. They will be here, and deals will need to be made between the countries, is our expectation. So I've already talked about the de minimis exception because it's one of the exceptions that expressly apply to the reciprocal tariffs. But as mentioned, up to $800 worth of goods each day can be brought in duty-free, even if that product would be subject to 25% duty or whatever duty based on the reciprocal tariffs. It's important because it doesn't require activity. It allows for shipment through commercial carriers. Again, on this $800 per day imported basis. And so certainly for a low volume import can be a significant mitigation technique if shipments can be varied. There were issues, and you can read about the current events, but ultimately the de minimis rule was put back into effect, even for China. Foreign trade zones, FTZs, there are generally options for tariff inversion, but under these most recent rules, there are some additional sticking points that prevent taking full advantage of FTZs. Foreign material brought into an FTZ, generally speaking, can be brought in as foreign material that is subject to duties at the time of export from the FTZ. But these new rules essentially say whatever comes in from these countries subject to these tariffs, this tariff will essentially be stuck to that product, and you can't manufacture your way around it. So that's significant. It doesn't allow for as much of a use of the FTZ to mitigate tariffs any longer. However, FTZs allow for diversion of tariffs. You don't pay at the time of import, even though, as I just mentioned, the amount is set. You won't pay those duties until exportation. Also, it allows for reduced payment of merchandise processing fee. Essentially, you pay a small amount up front, and then later you'll pay the full tariff amount. So imagine bringing a product into the U.S., manufacturing it and shipping it, let's say, to Canada. Without using an FTZ, you'd be responsible for bringing products into the U.S. and paying the duty on the full amount. But by using an FTZ, this MDF is set on a percentage of the overall value with a maximum payment of $630. So you could bring in a bunch of stuff into the US, into an FTZ, manufacture it, and then export it to another country, and you'd only pay that up to $630. And in most cases, much less, because it's a 0.34% fee that's applied to the value of the product when it's brought in. Then again, a couple of slides that just go in and talk about how some of these tariffs are unlikely to be avoided. The other options for mitigating the effects on business and techniques to mitigate tariffs deal with three principles of importation. What is the classification of the product? What is the valuation? How much is this thing worth that I'm bringing in? And what's the country of origin? Really quick on classification. Essentially, we have to be careful about what the product is classified as. However, there are specific rules that might allow for reclassification of the product because of previously we may not have paid much attention to what it's classified as, and there's a reasonable basis, but there might be a better basis for a different classification that has a lower tariff amount or perhaps no tariff amount based on the type of product that it is or based on where it's imported from. There are certainly risks for doing this wrong. And so these next slides just talk about some of those risks and looking at how you might want to go about this with the support of an expert attorney or a consulting firm. Consultants can be limited because they can't provide legal advice. Oftentimes we find ourselves working hand in hand with practical knowledge of a consultant and the legal expertise of our firm. The next kind of method, as I mentioned, is this valuation method. So it's really answering questions like, what is this thing worth? Just because we've valued it at this number in the past, might there be alternatives? I mentioned a middleman approach, in the coffee bean example. Oftentimes, supplier of raw goods could be even shoes from China, other things. A manufacturer isn't the one importing, and the buyer is not the one importing. There's a middleman. And are there options to take advantage of reduced values by using a full understanding of the supply chain? There's questions that involve, ensuring that there's arm's length transactions and everything's been above board, and ensuring that there's reasonable care, again, to avoid any sort of customs penalty. You'll see the 6 different options for valuation. The first and priority valuation method from customs is the transaction value, which is the price paid or payable. You saw in the previous slide a reference to the first sale and a middleman. In the transaction value method, there might be 2 transactions, right? There's the transaction the middleman perhaps purchases the product from, say from the bean farmer in Brazil, and then there's a transaction for the sale. The middleman sells this product to you as the coffee shop. That middleman has the first sale, and that first sale might be the option for reducing the value, because certainly the price the middleman pays is significantly less than the price that you pay, because the middleman has to make money. And customs rules allow for us to take advantage of those differences. The next kind of most common approach, as we skip through the identical goods transaction value or the similar goods, can be the deductive value, which is essentially the final sale price reduced by certain allowable expenses. Things like transportation costs, insurance costs, things that happen on the US side. Then it kind of interchangeably is this computed value method that's going the opposite way, starting with the cost of the materials, the value of the materials and the processing, and then adding certain items, such as packaging costs, adding items such as reasonable profits and general expenses that could be expected, again, all on the foreign side, and not adding any of the US added expenses. And then finally, there's a method called the fallback method, which says if none of these apply, customs will allow for you to customize one of the approaches to make it fit the facts and circumstances. Because we're running a little short on time, I'll allow you to read through some of these specifics. I've tried to give as much detail as I can about the options and the restrictions for the different methods. Again, the primary ones that are discussed. There's also this approach called an assist. You need to take into account any of kind of the built-in free activities, whether it's long-term tooling or consumables that are used for manufacturing your products. Those need to be, generally speaking, added to the value of the product. And then kind of the closing on this is you have to exercise reasonable care, and there are certain forms that need to be followed, that need to be supplied rather with customs information and other generally business kept records like POs and invoices and perhaps even development records to help justify your change for classification, your change for valuation, and others. And then I've also talked about these mitigation techniques of the Section 9802 tariffs, or Section 9802 program, which allows for reductions in the total dutyable value. And there are certainly others throughout the existing customs rules that your broker might be able to help with, and certainly we can assist with in order to address any of those issues that might be specific to you. So Holly, we've got about, I think, 7 minutes or so left. If you want to throw some of those questions, I'm happy to answer them, and we can also come back to some of my kind of long-term client questions that might be on point for some of the issues that your members are having.
Wonderful. Thank you. A lot of information, great information. Hopefully this is a good jumping off point for a lot of you listening in to this webinar on tariffs and how they might be impacting you. To talk with your vendor, with your broker, with an attorney, to look at the contracts that you have, to ask some of these questions, to have the information, just basic information to start the conversation, because a lot of times that's the most difficult part of this very uncertain, complicated journey through trying to figure out how this impacts you. So a few questions. Great example with the coffee sellers and how that process works. And there were a lot of questions related to who pays the tariff, how does that get passed down from the initial payment to the person who's selling it at their store. I think we covered that. The one area that I think might be helpful to explore a little bit, because there is that exemption of those products that are in transit. And you had mentioned that the tariff won't be in effect for those in transition until, I believe you said May 3rd. Is that correct?
May 27th.
Oh, May 27th. Much
Yes.
longer than May 3rd. So what does that process look like? If there's a small business owner who has products coming over, and they are, concerned about when the shipment arrives. Is it when those shipments get off the cargo ship? Is it when the ship docks? How does that play into effect, and what can they anticipate?
Yeah, great question. There are some specific mechanics that are required. I didn't include those in here because typically I would expect most of you are not the ones filing the paperwork. You have a broker that's doing the paperwork for you, but you should bring up this exception, which there's different chapters of the HTS code, and chapter 99 is the one that provides for either the need to pay additional duties or kind of coverage from those duties on these exceptions. There's a specific chapter 99 subheading that applies to this exception number 3. And so that would need to be included in the 7501 customs form. So the document that your broker files, they need to clearly designate we are claiming an exception because we satisfy this requirement. The requirement is twofold. The product, and you see it here, had to have been loaded on the vessel. Let's see if I can do this. I was trying to highlight it, but had to be loaded on the vessel. Here we go. Loaded on the vessel by April 5th and kind of there, entered for consumption or withdrawn from a warehouse for consumption by May 27th. And that means essentially clear customs. It might be in a warehouse in bond and it's being held outside, quote unquote, the US. And so it needs to clear customs by leaving that bond, or it needs to clear customs by having the 7501 entered and the duty paid by that May 27th deadline.
Okay, that is very helpful. At least it gives them again, a starting off point to have that conversation to make sure that, if they, if the small business owner feels that this might be an exemption, to talk with the person that they're purchasing the products from, to see if that is in fact the case. A few other questions. So related to, there were a few questions on, I have a product that I import from Israel. It is subject to a 14% tariff. I believe it's 14%. I have a product that, is there any way to, kind of plead my case for an exemption? Are all products from those countries more generally subject to the tariff? So if you could just kind of reiterate what you mentioned at the beginning about specific products from those countries, and if there's any process of kind of claiming an exemption specifically for you.
Yeah, that's a great question, and it's a frustrating one because, I'm not frustrated to have the question, but it's frustrating for you as the companies with those questions, because we were used to a process where we did have the ability to file and ask for an exception. In this case, the only exceptions that exist are the ones that I talked through on those 12 different examples. So there is no process for filing and requesting special treatment. There is no process for submitting data and having either Commerce or USTR make a decision. The best advice that we have is take advantage of lobbying opportunities that might exist, or even not even organized ones. Call your local congressman or woman and ask for a meeting and talk to them. That's about the only pleading opportunity, but it's not a guarantee. There's no mechanism in place. There's no process for it. It's really just find your own way as you go.
Okay. And really good point of, if you find yourself impacted by these tariffs and you are looking for some relief, write your congressperson, write your elected official, call their office and let them know how this is impacting you specifically. We do have a lot of members who are in the agricultural business, and so they are, some of them will be subject to the retaliatory tariffs on U.S. exports to other countries. Right now, it's China is out there first in, or at least the biggest of the tariff imposed on U.S. exports to China. Have you heard of any measures or any programs to help those who are impacted by retaliation tariffs of their exports?
No, there's really unfortunately the same answer. There's not really processes that we've been aware of. What countries are doing is kind of just matching, what we're doing to them. And so we've not seen any specific programs, solutions, etc. The closest is really kind of avoiding the retaliatory tariff, especially in the USMCA countries, where at first, when this was first implemented for about a week, produce from Mexico and produce from Canada, those were all subject to the IEEPA 25% tariff. However, with the exclusion or exception that USMCA products are not subject to those tariffs, that's been a relief. And I don't believe there's been any retaliation on those products on the North American side. But yeah, unfortunately, globally, it's a case-by-case basis. But I should say, just like your lobbying effort that you're interested in, calling your congressman, we can help with that. We have affiliations in China, in Europe, where we could reach out and see, well, is there a specific issue or opportunity? So never hurts to ask us and ask, again, your congressman or whatever, for opportunities that just to plead your case or to find out more information.
Great. And also, because the environment's changing almost by the hour on the different levels of duties, tariffs that are subject from different countries, and for them also. Is there a place for small business owners to go to see what those levels are that might be impacting those products? Is there kind of a central repository where they can get this information?
The best option you have, and this is not meant to sound sales pitchy, but is to visit our website. We do keep track of these things. There is no, government website, so to speak, that does keep track of these things. It's really a bunch of folks doing it on their own. So, I would recommend either getting a publication, even the Wall Street Journal attempts to on a regular basis do this, but they're always having updates and the newest, hottest news. You can find, like today, we published an alert that outlines all of the reciprocal tariffs. You'll see in the presentation that you'll get here that there's that slide that has what's in effect and what is likely to come. And you can receive all that, by going to our website and also, by circulating this, or as mentioned, feel free and reach out to me and I'll throw my contact info up on the screen really quick. Right there, zajac@butzel.com. Happy to help any of your members try to address these issues.
Wonderful. Thank you. And also because of, there are a lot of conversations and dialogue related to proposed tariffs on different products, just recently hearing about the pharmaceutical industry. So having that information available so you can make the best decision for your business in anticipation of things that might be coming up is also helpful. One question before we end the webinar. From Renee is if the work that we do is in the US, but the payment requests are outside of the US, how do tariffs affect that transaction, or do they?
Yeah, the only thing that affects the obligation to pay tariffs is bringing a product into the US. So if you have, you just pay some parent company in the Netherlands, but you're doing all the work here. You're locally sourcing your components and you're doing all the assembly and manufacturing here, or whatever the specific industry you're in. You're doing that work here. Paying someone else is not relevant. It could be relevant that you're bringing in components from other countries, right? And then that component might be subject to a tariff, but your final product, that itself won't be subject to a tariff. If you're doing the work in the US outside of an FTZ, just normal manufacturing or assembly activities, you shouldn't be worried about that product being subject to any tariff, regardless of who you pay.
Okay, wonderful. Well, thank you so much, Mitchell, for all of your insight and help in trying to navigate this very complicated situation that is causing heightened anxiety, a lot of uncertainty out there. And this was hugely helpful, at least getting small business owners started in the conversation, figuring out next steps on how to approach how this might impact them, and where to find information. Again, for those who still have questions related to trade policy, please email NFIB at info@nfib.org, or you can directly reach out to Mitchell if you have very specific questions related to your business and the trade policy changes that have been occurring over the last number of weeks and are likely to be ongoing. Again, thank you, Mitchell. This has been wonderful. And thank you for everybody listening to the webinar.
Thanks all. Have a great day.
Thank you all. Please visit nfib.com/webinars for all of our webinars on demand. That concludes our presentation for today. Take care.